Okay, welcome back. Kumusta po ang ating mga followers, ang ating pong mga tagapanood. Magandang gabi po sa inyong lahat. Okay, so I received a lot of requests coming from our friends to come up with a video regarding retrenchment or commonly known as layoff. So what is this retrenchment is all about? Okay, so in the case decided by the Supreme Court, the case of Waterfront Cebu City Hotel versus Maria Melanie P. Jimenez et al. Okay, JR number 174214, June 13, 2012. The term retrenchment was defined as the termination of employment initiated by the employer through no fault and without prejudice to the employees. Okay, so it can only be resorted to prevent substantial or reasonably imminent loss. Okay, say during a recession, depression, seasonal fluctuations in business activity, or during lulls occasioned by lack of orders, shortages of material, or conversion of the plant to a new production system. The introduction of new methods or more efficient machinery or automation. In other words, business losses of or lack of works or considerable reduction in the volume of business are valid reasons for termination of employment. Yun po yung mga reasons ng retrenchment or layoff. Okay. So, however, in the case of Lambert Pawn Brokers and Jewelry Corporation versus Binamira, GR number 170464, decided by the Supreme Court on July 12, 2010, it says that cost reduction or cost saving measures prior to retrenchment are required. So, required ang cost reduction or cost-saving measures bago ka mag-retrench ng employee mo. So, mandatory po. Parang lumalabas na mandatory. And that's why, at this time, okay, we are in a pandemic, the Department of Labor and Employment come up with the Advisory Number 9, which was amended by subsequently amended by Advisory Number 17, okay, thus 2020, is suggesting to all employers to adopt remedial measures as alternative coping mechanisms instead of removing employees or closing businesses. So, nagbigay na siya ng kanyang cost-cutting or cost reduction measures, advisory sa mga employers. Okay, the said advisory recommends the adoption of flexible work arrangement, okay, such as reduction of work hours and or work days where the normal work hours or work days are reduced. Okay. Rotation of workers whereby the employees are rotated or alternately provided work within the week. Okay. Forced leave wherein employees are required to go on leave for several days or weeks utilizing their leave credits. Transfer of employees to another branch or outlet of the employer. Assignment of employees to other functions or positions. Partial closure of some units or departments. Other feasible work arrangement. Adjustment of wages and wage-related benefits provided that the employer and the employee agree voluntarily in writing, but this should not exceed in 6 months. Okay, both employers and employees are encouraged to explore other alternative arrangements to cushion the effect of the loss of income to the employees. Okay, guidelines optional to employers and businesses. Okay, should an employer wish to adopt the flexible work arrangement, it must post a copy of the advisory in a conspicuous place in the premises. Furthermore, the employer must notify the regional office of DOLE, or Department of Labor and Employment, where the office is located, with regard to the adoption of such arrangement through a report form. Okay, it must be emphasized that the flexible work arrangement are temporary in nature and subject to the prevailing conditions of the company. Okay, this is how to properly adopt remedial measures to mitigate the losses caused by current pandemic in the workplace. So, mandatory po ang cost cutting bago po tayo mag-resort sa retrenchment or mag-lay off ng employer. Okay. The right of management to dismiss workers on the ground of retrenchment to prevent serious losses is governed by the Labor Code, specifically Article 283 of the Labor Code. Okay, this is one of the authorized causes of termination of employment. Okay, however, before one can dismiss employees on the ground of retrenchment, at least the following 4 elements must be proven. Okay, so number 1, the losses expected should be substantial. So dapat malaki ang substantial, malaki or yung impact ng losses niya. Okay? The substantial loss apprehended must be reasonably imminent, and such imminence can be perceived objectively in good faith by the employer. So imminence yung talagang reasonably imminent yung losses niya. Alam nating darating talagang in good faith magkakaroon ng malaking losses, substantial losses yung company. And that is of course being assessed in good faith by the company. Hindi siya guni-guni na, hindi, malulugi ako, kailangan kong mag-retrench. Okay, hindi po ganon. Okay? It must be reasonably and necessary and likely to effectively prevent the expected losses. The employer should have taken other measures prior or parallel to retrenchment to forestall losses such as cutting other costs other than labor cost. Yan sinabi natin kanina, mandatory na po siya. Yan po number 3, na bago po siya mag-retrench or magbawas ng labor cost, dapat mag-cut cost mo na siya on other expenses ng corporations. And that should be proven. Okay? Kasi part po ng basic elements yan required that the company or the corporation should prove para legal po or allowed po yung pag-retrench niya. Okay? Ng employees. Okay. Number 4, the alleged losses, if already realized, okay, and the expected imminent losses sought to be forestalled must be proven by sufficient and convincing evidence. It bears emphasis that serious business losses should be proven by financial statement duly audited by an independent external auditor. So it means to say talaga na hindi lang po basta-basta talaga pala pwedeng retrench ang mga employers. So in fact, required po na mag-present siya ng kanyang audited financial statement conducted by an independent external auditor para po hindi self-serving. Okay, if the grounds for retrenchment are not proved, yung 4 na sinasabi natin kanina, if they are not proved, then the retrenchment will be declared illegal and of no effect. Okay, if the retrenchment employee signed quit claims, if the retrenched employee signed quit claims, they may be declared invalid even his acceptance of the retrenchment pay does not amount to estoppel, which does not bar him from contesting his separation. Okay. In accordance with the Labor Code, for valid implementation of retrenchment program, the employer must serve written notices to the employees and to DOLE at least 30 days prior to the intended date of retrenchment. Specifically, the purpose of which of such previous notice to DOLE must be to enable it to ascertain the verity of the cause for termination of employment. There must be fair and reasonable criteria to be used in selecting employees to be dismissed on account of retrenchment. So, hindi sila pwedeng turo-turo lang na dahil pinag-iinitan ko ito, matigas ulo nito, or hindi ito sumusunod sa akin, or may mga personal grudge ka not related to work. Hindi po yun yung magiging dahilan kung bakit ikaw ay pipiliin na ikaw ay ma-retrench. So, mayroon pong criteria na sinusunod. At kailangang ipakita din po ito ng employer. Okay. Number 1, okay, it could be like less preferred status. Example, temporary employees or hindi regular employees. So, they must go first. Okay. Efficiency rating, performance-based. Okay, then seniority. Okay, the last in, first out rule indicates that as between 2 or more employees affected by retrenchment program, the last one employed will be the first to go. Seniority of the ones hired earlier, therefore, prevails. Such rule has its merits, but its observance is not statutory duty of the employer. Okay, finally, the more important aspect in termination of employment is the payment of the employee's separation pay, which is equivalent to at least 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. A fraction of at least 6 months shall be considered as 1 whole year. So, mahirap to intindihin sa mga hindi po nabibiyaya ang nakapag-aral. Kasi sabi dyan, requirement is ng separation pay, at least 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. So, ibig sabihin po, ang separation pay at least 1 month, hindi po dapat bababa ng 1 month kapag ikaw ay na-retrench. Okay? Or a fraction of at least 6 months shall be considered as 1 whole year. So, paano po yun, sir? Parang ang hirap pong intindihin, attorney. Paano po ba yan? So, example po, if employee A lost his job due to retrenchment, was with the company for at least 3 years. Okay, nakapag 3 years po si employee A and gets a monthly salary of 20,000 a month at the time of his termination, his separation pay should be calculated or computed as follow. So, 1 month pay, at least 1 month pay. So, dapat hindi bababa, at least 1 month pay, 20,000. Hindi dapat bababa sa 20,000. Pero naka 3 years po si employee A. So, paano po ang computation nun? It should be 1 month, 1/2 month salary for every year of service. So, 1/2 times 20,000 times 3 years. Kasi naka 3 years po siya, no? So, 1/2 times 20,000, that's 10,000. Times 3 years, that is 30,000. Okay, the higher amount is of course 30,000. So, employee A should receive the amount of 30,000. Kasi sabi natin, di ba, 1 month pay or at least 1/2 month pay for every year of service, whichever is higher. So, ang month pay niya, which is 20,000, but then upon computation, 1/2 month per year of service, 1/2 month pay per year of service. Okay, so times 3 kasi naka 3 years siya, lumalabas na 30,000 pesos. So, the higher amount is 30,000. So, employee A should receive the amount of 30,000. So, ganun po ang pag-compute po ng separation pay. Now, question. Is the separation pay of retrenched employee subject to tax? Taxable po ba ang separation pay? Okay, so under section 32, capital letter B, number 6, small letter b of the tax code. Okay, sa ating NIRC, National Internal Revenue Code, o yung or known as tax code of the Philippines. Okay, any amount received by an official or employee or by his heirs as a consequence of separation from the service of the employer because of death, sickness, or other physical disability or for any cause beyond the control of the said official or employee shall be exempt from tax. So, hindi po taxable ang separation pay. So, yung separation lang pay lang po yung hindi taxable. All others, of course, taxable pa rin siya. Kasi nga, hindi lang naman separation pay ang makukuha ng empleyado kapag siya ay niretrench ng employer. Siyempre, mayroon pa rin po siyang 13-month pay and other expected salaries relative to his employment. So, yun lahat po yun taxable. Okay, so that's all for retrenchment. And if you have questions, just leave a comment below. And if you haven't subscribed yet to my channel, please subscribe and click the bell button para updated po kayo sa mga subsequent releases ng video po natin. Okay? Maraming salamat, mag-ingat at mabuhay po kayong lahat.